In this lecture, we will be discussing testamentary freedom. As you may recall from your property courses, property owners in the U.S. have wide latitude to alienate or dispose of their property in the way that they see fit. This freedom is often referred to as the freedom of disposition. In this class, we will address the degree to which this freedom continues on after the property owner dies. We call the freedom of disposition at death testamentary freedom. The question that we're going to frequently confront in this course is how much power the deceased should have to control the transfer of their property from beyond the grave. In other words, how much should we allow the dead hand to control the affairs of the living? In the U.S., the deceased are given pretty generous testamentary freedoms. What this means practically is that whenever possible, a court will try to understand how the deceased wanted their property to be distributed at their death. And then they're going to try to honor their wishes. So the default in the United States is that the intent or the wishes of the deceased are going to be what governs. Now, despite this wide latitude of freedom, testamentary freedom in the United States is not absolute. And we're going to spend quite a bit of time this term discussing the exceptions to this default rule of testamentary freedom. Now, the laws that govern the transfer of property at death are heavily influenced by cultural values that have become embedded in the law over time. Early U.S. social policy was heavily influenced by Puritan ideals. Early Puritans believed that poverty was a direct result of laziness, and that laziness was synonymous with sin. In their eyes, God rewarded those who worked hard by bestowing upon them wealth. And because wealth was seen as a reward for hard work, it followed that the owner of this wealth should be able to have the freedom to do what they wanted with that wealth. And given this early influence, it's not really surprising that U.S. succession law is premised on the principle that Americans should be able to dispose of their property as they see fit, even after death. You've done some reading in your text about the arguments for and against testamentary freedom. What are some of the arguments for and against testamentary freedom? I'd like you to list two arguments for and two arguments against testamentary freedom. In other countries, they utilize elements of forced succession in deciding who gets property after the deceased has passed away. And they used forced succession to a greater degree than we do here in the U.S. Well, what is forced succession? Forced succession is when private property passes as it's mandated by law. So the law decides who gets what. And after those forced shares are distributed, then perhaps the courts will look to what the deceased intended. Why might some countries opt for forced succession instead of testamentary freedom. Even in the US, where testamentary freedom is the default, there are many limits on testamentary freedom. For now, I'm just going to go over two broad categories or sets of limitations. The first category are state legislation or regulations. So they're just state laws. Like property law, succession law is largely a creature of state law. And as such, the states have broad authority to regulate succession. So given that authority, states can vary in the degree to which they limit the testamentary freedom. Because of this variation, we're going to spend most of our time discussing the rules that are spelled out in the Uniform Probate Code, or the UPC. We're going to look to cases as examples of fact scenarios that can arise, that can raise particular issues that we're interested in. But for exam purposes, we're going to treat the UPC as governing law. Now, there are multiple versions of the UPC, so you may be wondering how you'll know which version to use. Well, your textbook provides excerpts of the most widely adopted version of the UPC for each of the issues that we're going to discuss. So I'd like you to refer back to your textbook for the proper law to apply. Okay. So the first common limitation we said are state laws. The second we're going to talk about today are public policy limitations. These come up particularly when related to testamentary gifts that have conditions placed on them, or conditional gifts. Now, you may recall from property the rule against perpetuities, and that is one way that that the law limits conditional gifts. And we'll revisit RAP at the end of this course. But aside from RAP, the law also limits a descendant's power to condition a testamentary gift on the beneficiary's behavior. Okay, so this will come up when you talk about the beneficiary's behavior. The beneficiary is the person who is receiving the testamentary gift. The beneficiary is the person who is receiving the testamentary gift. So, testamentary gifts that condition the gift on the beneficiary behaving in a certain manner, they are typically upheld unless they violate public policy. Shapiro v. Union National Bank is an example of a case involving a conditional testamentary gift. In this case, the father bequeathed a gift to his sons, but the gift was conditional on the sons marrying within 7 years of the father's death. The sons had to not only get married, but they also had to marry a Jewish girl whose parents were both Jewish. One of the sons sued, and they argued that this condition violated both the 14th Amendment of the Constitution and public policy generally. We're more focused in this class on the public policy argument. The court did hold, though, that the conditions placed on the gift did not violate the 14th Amendment. On the public policy concern, the court also held that the conditions were not against public policy. And their reasoning was that the conditions were only a partial restraint on marriage. A partial restraint on marriage. This case helps demonstrate the extent to which courts are going to defer to the descendant's testamentary freedom. It also starts us off on our exploration of conditions that restrain marriage. So from Shapiro, we see that gifts that require a beneficiary to get married to someone within a reasonable time and even require the beneficiary marry someone from a particular religious background, these are what are called, we said, partial restraints, and we said those are valid. Those are not against public policy. Those are valid. But not all restraints on marriage are valid, as you may have guessed from the court's use of partial here. Okay, so what types of conditional gifts are invalid? Are invalid against or against public policy? The first type of gift are gifts that have conditions that amount to absolute restraints on marriage. These are considered to violate the fundamental right to marry, and therefore are usually held by courts as being against public policy. If a gift has a condition that is an absolute restraint on marriage, then that gift is void. So an absolute restraint on marriage is different than a partial restraint, because an absolute restraint on marriage is a condition that requires the beneficiary does not get married at all to anyone. And you can see how that differs from the facts in Shapiro. Well, what about restrictions governing religion? We saw in Shapiro that it was permissible for a decedent to condition a gift on marrying someone from a particular religion. But the court draws the line at conditions on the beneficiary practicing a particular religion. So conditional gifts that require the beneficiary to practice a religion are also invalid. Now, these restrictions on the practice of religion by the beneficiary violate public policy because they implicate religious freedom. The third condition that we're going to talk about today that is often held as invalid is one that requires the beneficiary to separate or divorce a spouse, separate from or divorce a spouse. These gifts are said to violate public policy because they encourage divorce, and divorce is viewed as a negative thing by and large by the courts. Now, you want to be careful here to distinguish between conditions that encourage divorce versus those that just provide support in the event that a divorce happens. Conditional gifts that are meant to provide financial support for individuals after they have divorced Those are valid. So you might be wondering how you distinguish between the two scenarios. Well, courts will look to what the decedent's intent was. So if the decedent's intent was to simply provide financial support for an individual if they were to get a divorce, then it would be valid. But if the decedent's intent is to require that the beneficiary separate or divorce to get the gift, thereby encouraging divorce, then it is invalid. As you can see, it's a pretty thin line here, and it can be difficult for courts to determine what the decedent's intent is. So there are many other restrictions on conditional transfers due to public policy, but for the purposes of this course and the time that we have today, we're just going to focus on these three. The final issue I'd like to discuss in this lecture is what happens with property that is acquired after the death of the decedent. This is referred to as posthumously acquired property. Your textbook goes over nuances and variations in the rules, and your textbook uses the Shaw Family Archives case, particularly because the fact pattern is interesting. But that case is complex, and for our purposes, we're going to simplify this. We're just going to refer to the UPC rule on the issue. And that is UPC Rule 2602, 1990. This rule gives the decedent testamentary freedom to dispose of property acquired after death. It's a pretty simple rule. So the decedent has testamentary freedom in regards to property that is acquired after death. So the property acquired after death is essentially treated the same way as property owned at death. Now you may be wondering if I'm going to require you for exam purposes to write down the number of the rule or the year of the UPC. I'm not. I'm looking for you to state that, according to the UPC, it probably would be good to put the year 1990 and then to give me a summary of the rule. So let's recap what we reviewed in this lecture. So we spent time defining what testamentary freedom is. We talked about the history of the U.S. that contributed to the testamentary freedom that is afforded to decedents in the U.S. We briefly talked about forced succession. And we discussed some limitations to testamentary freedom. And specifically, we said that states can pass legislation or regulations, and that there are some public policy limitations. And those public policy limitations come up most often when we're talking about conditions placed on the behavior of the beneficiary.